Fleischer.
Good morning, Your Honors.
Have I pronounced it correctly?
My name is Robert Fleischner. I represent Robert Magrini, who is the appellant in this case. May it please the Court. When Mr. Magrini first requested an emergency hearing from the District Court under the third paragraph of Section 12B of Chapter 123, he had been held against his will at the Newton-Wellesley Hospital for 12 days, and he was facing the possibility of another 10 days before he could appear before a judge to challenge the basis of his commitment. The statute, which is a question here.
Well, let me ask you this. Isn't this all moot in a way? Because didn't he then enter into a voluntary commitment?
He did, Your Honor. After his request for the emergency hearing was denied, the next day, I believe, he signed what's called a conditional voluntary under Sections 10 and 11.
So doesn't that mean that he no longer had any quarrel with this?
But you
No,
said
it
this
doesn't.
is capable of repetition.
It is, Your Honor. It's capable of repetition and avoiding review. This case would have been mooted, technically, under any circumstances, whether he had signed the voluntary or that he had stayed in the hospital and gone to the hearing 4 or 5 days later. So his action, for whatever reason he took it, for whatever reason he had for deciding to stay voluntarily, it does not change the fact that the case would have been technically moot under any circumstances. The timelines are so...
Are you complaining that the readmission was unlawful only because of the procedural defect, because it wasn't within the 3 days' time?
No,
And then he was readmitted.
He was the claim that Mr. Magrini made in his request, the reason to believe, in the words of the statute, is he had a reason to believe that there was an abuse or misuse of Section 12B, was that he had been, after he'd been ordered discharged by the district court, he had been immediately readmitted even before he was discharged.
Right.
And he was claiming that that was an abuse.
Okay, now, isn't that obvious to the judge on the papers? If that's what you're claiming, that's why I asked you that question. If that's what you're claiming, that was obvious to anybody looking at the papers.
That was obvious from anyone looking at the papers.
Okay, so then why do you need a hearing to resolve that?
Because there are a number of questions which, first of all, the statute says that there shall be a hearing. And we believe that we argue that what the legislature meant by the word hearing is actually a hearing at which the patient is able to present evidence. There is
evidence of what?
Well,
what
he
is
would
there
be
going to be evidence of if this was the same judge who was familiar with exactly what had happened, and you just said the only complaint made was misuse of the admission and readmission process.
Well, there's a context in which everything happens and very quickly in the course of both this admission and all mental hospital admissions, Your Honor.
But evidence of what?
Well, he could have shown, he might have been able to show, for example, that the doctor admitted him in a fit of pique, that he was angry.
Well, did
at
he
the
submit
district
an
court.
affidavit?
I'm sorry, did he submit an affidavit?
Did he submit an affidavit?
No, there's no provision for him submitting an affidavit.
But it was a written-out spelling of the basis of the
He actually submitted
emergency
considerably more than the district court procedures required. There's a one-page form.
What he can contest that emergency hearing is limited to what's itemized in the first paragraph of 12B. Not the substance of the medical diagnosis.
No, I disagree with that, Your Honor.
How can you when it says the emergency hearing is limited to the provisions of this subsection?
Yes, and Section 12B has actually two parts, or several parts, but some parts of that section are procedural. For instance, you have to be informed, you have a right to counsel. But it also contains the standards for commitment, which is that the person will create a likelihood of serious harm to himself or others. And the district court procedures, the transmission from Judges Zoll and Connolly, agree that can be challenged as well.
I'm suggesting they may be wrong, and this form that she's provided may go too far.
Well, I think in this instance, I think that there are things that are wrong with that transmittal, but this is not one of them, Your Honor. The Section 12B includes, as I just said, both the procedural things that have to happen in a 12B and the substance of 12B. It may be helpful to distinguish between 12A and 12B in this situation. 12A is an application for admission. 12B is a determination by a designated physician that the application that that the admission is appropriate.
Didn't Dr., is it Orlikov? Do I have the name right?
It's Orlikov, yes.
He would qualify as a designated physician, right? He has admitting, he's on the staff of Newton-Wellesley, is that
Well,
right?
he is a designated physician. That means he's designated by the Department of Mental Health.
And I'm just trying to understand, I'm not arguing about the hearing part, but I just want to see, given that he is, if the hospital had given notice to Mr. Magrini that the judge had ordered him discharged because the application under Section 7 and 8 was beyond the time,
Yes.
right? Couldn't Dr. Orlikov have at that point, so they give him notice, they say you're discharged, and then Dr. Orlikov, because of who he is, a designated physician, couldn't he have kept him there?
Well, that's precisely the question that the district court should have been asking at the emergency hearing.
Is the
You mean, am I wrong, or
No,
you mean
well, we don't-
theoretically I'm right, but
theoretically,
you would say,
theoretically, you're correct.
You're right,
Although
but he could challenge whether there was a substantive basis to do that. Is that what you're saying?
that's what I'm saying.
Okay.
Dr. Orlikov did not examine the defendant?
It's not clear. It appears from the record, what little of the record there is, that he actually, when the hospital got the notice early in the morning that the judge had ordered him discharged, that he immediately executed a 12B. The only note in the progress notes, which we've included in the appendix, is a note that was made 15 minutes later. So it appears from the record that the examination actually came 15 minutes after the admission under Section 12B.
Does Section 12B doesn't seem to expressly require an examination by the designated physician, but is at least implicit from
I
Section 12A?
think it actually, Section 12A does not require an examination by the licensed physician who can transport. But I think that it is clear, I think in 12B and in the Department of Mental Health licensing regulations, that there has to be an examination by the 12B doctor within 2 hours of the person's arrival. So yes, I think there has to be an examination.
Explain to me here, if in fact the patient fills out a form describing why the reason to believe that the admission was a result of a misuse of the process, and the judge looks at it immediately upon filing and in essence says to him or herself, I'm going to assume everything in this statement is true, so I'm going to give full faith and credit to the statement, but that's not a basis upon which I will, I'm going to dismiss this petition. I mean, isn't that enough?
We think not. We think the statute, we argue, requires a hearing. And in the context of a restraint of liberty, which this is, and in which this court and the United States Supreme Court have characterized as a massive restraint of liberty, that this extra intervention added by the legislature in 2000 requires an in-person hearing and an opportunity, no matter how informal, no matter how limited, but it requires that.
It doesn't require an evidentiary hearing.
Well,
It
the
can be decided on the papers.
Well, we think
Well,
not.
he disagrees.
Your Honor, there are other places to look in this very chapter for how the legislature has dealt with hearings in the context of civil commitment. We suggest that you look, for instance, at Section 5, which it provides for the expansive civil commitment hearing, and Section 8B, subsection E, which has to do with forced medication. And in that section of the statute, the legislature specifically provides for hearings on the papers and for a process that the judge must go through before doing that. They didn't do this in this section.
Do lawyers instantly appear for these?
Yeah, they do, actually. There's quite a remarkable system
Under Section 12B,
under
right?
Section 12B.
Because I know there has to be immediate notice to CPCS and
that's
so
right.
forth. Because wouldn't it be expected that a lot of people who are committed under this involuntary procedure, their first reaction is going to be, I don't belong here. I'm not a threat. I'm not mentally ill. So the district court could do almost nothing else except hold these hearings. But do the CPCS lawyers filter them out and say, here's a doctor's report and this person is really sick or a substantial threat? Or do they go down and want an evidentiary hearing with every single one of them?
We've included in our reply brief a report that the legislature requires from the Department of Mental Health each year on the implementation of this section of the statute. There's an average of about 7,000 Section 12B admissions each year.
Right.
And there have been an average of about 46 requests for hearing.
By
since-
and we can assume that's by CPCS.
I'm not sure that you can assume that, but I think that's logical to
Yeah,
assume.
because you said the system is pretty
Right.
efficient and the thing goes immediately to
That,
CPCS.
that means that less than 0.5% of the 12B admissions request a hearing.
And this 12B admission is your emergency 72-hour admission. They have to file a commitment,
That's right.
commitment petition within the
Yep.
72 hours.
That's
in
correct.
order to, and then that would trigger a full hearing within what time?
Within 5 days thereafter.
Okay.
And that's the Section 7 or 8 hearing.
That's a Section 7 and 8 hearing. That's correct.
Can a doctor, I'm just going to get back to that question about the examination, can a doctor rely on some other, can the admitting doctors rely on some other doctor's examination for purposes of admitting a patient under 12B?
Well, I think that they have to make an independent determination, Justice Spina, but I think that it would be just the usual practice of medicine would not make it unusual for a doctor to rely on some other doctor's impression.
If the person is brought over there from an emergency room of another hospital, and they call the emergency room physician, and he says, gee, I think this person should be committed, and they say, fax me your report, certainly they could rely on that.
Well, I think they can, but they still have to make an individualized
Oh, sure.
determination, and they have to do it within 2 hours
The
of the
case really
arrival.
comes down to, could they readmit this person or recommit this person 15 minutes after he should have been discharged?
That's
That's the bottom line.
As I suggested to Justice Botford, that's the question that we believe that the district court should have been asking. It may be that was entirely proper, but there's no way to know that without a hearing, and for the judge to hold that hearing.
Mr. Fleischner, could I ask you this? It's the abuse or misuse of the provisions language which I find interesting. In other words, one way to write the statute is any person admitted under the provisions of the subsection may request or request through counsel an emergency hearing. That would be perfectly straightforward. But that isn't what the statute it says. It says, or who has reason to believe that such admission is a result of an abuse or misuse. That's a filter.
Yes.
So who determines whether there's a basis for reason to believe there has been abuse or misuse?
Well,
CPCS.
well,
Or the patient?
No, it's, the judge plays some role there.
the first
Oh,
determinant, I
because
think
you're
Judge Graney
saying,
is,
But first it's
somebody,
you
you're
folks.
saying anybody who requests a hearing should have a hearing.
we have suggested that the judge can certainly make a determination and not hold a hearing if the motion is frivolous on its face, which is possible in this setting. But if the patient or his lawyer makes a very low threshold standing, which reason to believe we believe is, and by the way, it's the same standard that the doctor uses under Section 12A to admit someone, which I think is also a fairly low standard, reason to believe something probably close to probable cause, and the judge must hold a hearing. That's the language of the statute.
Does a patient have a right to a lawyer for purposes of the Section 12A proceeding?
No. No, the lawyer, the CPCS is called once the Section 12B is signed. This case is a little odd because another possible use or misuse is that both the doctors, both Dr. Clark, who signed the first 12A and 12B, and Dr. Orlikoff, who signed the second one, are both designated physicians. There was no reason for them to sign a 12A. They could have directly signed a 12B. That's a matter of some importance in the first admission, since the 12A was signed on the night of the 8th and the 12B on the morning of the 9th, which extended his commitment a full day. So we believe that the statute requires a hearing. The word shall has been interpreted by this court on several instances in the context of these statutes as being mandatory when a public official is given a duty that has to do with liberty. This is what the legislature was impressed.
But in terms of the content of that hearing, the reason that you say it needs to be evidentiary is you're saying because it's the word hearing by itself is contrasted to these other sections that specifically authorize paper?
Well, no, Section 8B authorizes paper. Section 5 does not, although you can waive a section. Under Section 5, you can waive a Section 7 and 8 hearing.
Are you saying it has to be an evidentiary hearing or just a hearing?
Well, we think that the judge, the district court judge, has some leeway in this. This is an emergency hearing, and in the same
The
way
judge
that...
can take evidence or can listen to argument
But
of
we-
counsel.
Well, we do think that there has to be an appearance at the very least.
No, I
and-
understand that, but there are lots and lots of hearings.
Yes.
You file a motion and you have a hearing. It's not an
Yes.
evidentiary hearing.
Yeah, there
I
has to be
understand
some-
you mean there has to be an appearance in front of a judge.
That's correct.
But it doesn't have to be
And
an
some meaningful
evidentiary.
hearing.
Yeah,
Some
it does
form
not
of
have, it
meaningful
does not,
hearing.
does not necessarily have to be evidentiary. There has to be an opportunity, because of the imbalance of the authorities and the small number of paper that's available, for the patient to present his case in person or through his lawyer to a judge.
Thank
Thank
you,
you.
Mr. Fleischner. Mr. Porter?
Good morning, and may it please the Court. My name is Michael Porter, and I represent Newton-Wellesley Hospital. The decision by the Newton District Court, which was upheld by the Appellate Division of the District Court, should be affirmed today for the following reasons. The legislative intent behind Chapter 123, the general laws, compels it.
Why do I look to the legislative intent when I seem to have pretty clear language in the statute?
Your Honor, it's the hospital's contention that the language of the specific subsection of Chapter 123 needs to be read in context with the statute in its entirety.
No, I understand that, but
It says shall hold a hearing.
shall hold a hearing, and it talks about shall hold a hearing,
Within 3 days,
no, it's
immediately.
talks about medical in the district court. I mean,
Yeah, the problem I have with the appellate division majority opinion is it goes off on with such words as the judge had discretion, the statute says shall, and then if the judge acted in good faith, none of that's in the statute.
I agree, and, Your Honor, I think that you rightly point out that in the near 40-year history of Chapter 123 being with the bench and the bar, that it continues to be misinterpreted and misapplied. For example, the appellate division pins Mr. Magrini's initial admission date as June 8th, where that was the day that he arrived at the hospital. The day that he was admitted is June 9th.
I
He
thought
was
I heard
admitted on the 9th.
I thought I heard Mr. Fleischner saying he was admitted on the 8th under 12A and on the 9th under 12B.
Respectfully, and I don't believe that that's what my brother had indicated, but respectfully, no one is ever admitted under subsection 12A. It's not an admission process that subsection describes.
Oh,
That
okay.
is it is the application for admission, and it's also the authorization under the statute to restrain the person while you're in the middle of this admission process.
But you're not, I mean, we're not going back to whether or not the judge was right in discharging Mr. Magrini because you hadn't met that 3-day deadline, are we?
No. I'm just simply pointing out that although I'm asking the court to affirm the holding in the appellate division's case, I'm just merely pointing out that the decision and the opinion is not mistake-free. That's one of the mistakes. Another one of the mistakes is that they had...
Excuse me, Mr. Porter, just say that to me again.
I'm asking the court to uphold or affirm the decision of the appellate division, but I'm just simply saying that the decision and the opinion itself
not mistake-free.
contains misstatements of the law.
What
For
is the problem with holding a hearing within 3 days? Do you have any problem with that?
I think that that's one of the key points to the hospital's position. The hospital does not have a problem with a hearing being conducted within 3 days of the admission. However, only if the judge, the district court judge, in his or her discretion, deems that it's necessary.
But how do you
But
get
how do you get
discretion into
discretion?
shall?
Because when you look at the statute in its totality, General Laws, Chapter 123, Section 5, for example, describes a particular processes and particular rights that are incumbent for any hearing that's required under the statute. And within Section 5, it says, for example, the district court cannot schedule a hearing until at least 48 hours has elapsed from the time that counsel has submitted an appearance.
Was Section 5 amended when Section 12B was amended to add this provision in 2000?
No, it wasn't, and they had the opportunity to do so because the legislature, in addition to changing Chapter 123, Section 12B, they also had to change Section 7 to reflect the shortened time frames that the court has to schedule the hearing. So,
but this is very specific. I mean, I should get it in front of me, but doesn't it say hold the hearing and it's got to be by either right then or within the next day? Doesn't it say that?
Yes.
it says shall, but it's the hospital's contention that shall, when it appears in a statute, is not exclusively and automatically mandatory. And in this situation, it's directory.
It says, shall hold such a hearing on the day the request is filed with the court or not later than the next business day. So all this four-day notice means nothing. I mean, you've got a piece of the statute that says somebody may request, and unless a delay is requested by the person through counsel, shall hold the hearing that day or the next business day. So I take it that's Friday or Monday. We're not doing it Friday or Saturday.
That's correct. However, as my brother had indicated, not only in his brief but in argument, that the statute affords the judge to dispose of, off of the papers, a request for a hearing that, in his term, is patently frivolous. If shall means shall,
he
then...
agrees with you on that.
But my point is that if shall means shall, at what point is the district court judge who's reviewing this paperwork, at what point does this discretion arise?
It may be that you are correct, that there's no discretion.
Well,
Except that it has this, that's why I asked
reason to believe.
Yes, and that's why the hospital is relying upon the line of cases that says that whenever you're dealing with a literal interpretation of a statute, if to stick to that literal interpretation leads to absurd or unintended results, that you can look to the legislative intent.
Why would, if you have no objection to these hearings, why would it lead to an absurd result? If you're the legislature balancing up a massive deprivation of liberty, correct? It's massive, and you provide an opportunity for a prompt, short, non-evidentiary hearing, nothing to say, it can be evidentiary. What's the absurd result?
The absurd result would be to require a court that, based on the paper that's been submitted not only by the patient but also by the hospital itself, that there's nothing to be added by requiring the personal presence of the parties.
But you don't know that. These things are done very fast.
What did the plaintiff allege here was the violation of subsection B when he requested the emergency hearing?
Nothing.
Nothing. So that clearly is a case where a judge could say there's no meaningful allegation of abuse or misuse, I'm not holding a hearing, correct?
Go ahead, answer the question, then I have a follow-up.
It simply highlights that if you have two prerequisites to a request for a hearing, one being that the admission status must be under subsection 12B, and the other is that the subject matter of the request itself must be one of an abuse or a misuse of one of the provisions of subsection B.
If somebody says, I have reason to believe, that's it. I have reason to believe.
But
that
he
there
alleged
has
nothing,
been-
did he?
He did. He filed a motion for an emergency hearing. He set out what the problem was, didn't he?
That's correct, but he makes
set out
allegations.
just a procedural defect.
Yeah, I was discharged, but they held me anyway.
Right, because of the improper procedure.
I mean,
What's-
he
that's
filed
the
this.
problem.
I'm looking at it.
It's the same judge that allowed the motion to dismiss that had been faxed in on Sunday the 18th that read the paperwork that had been submitted by the patient and the response by the hospital on Monday the 19th and was able to determine that based on what had been alleged, there was no need for a hearing and that the request for the emergency hearing had been denied.
Mr. Porter, the problem that I have with this is if I take your position and we're giving all this discretion to the judge, the exceptions are going to totally swallow up this very, fairly mandatory language.
Your Honor, I think it highlights the fact that when you read Chapter 123 in its entirety in context, not only the substance, but at the time that it had been amended.
One reason why we've asked judges to have hearings, the legislature has, is because sometimes it's not so clear from the paper, especially if it's somebody who may be in need of hospitalization. And it seems to me one way to look at the statute, very mandatory language, is that because the deprivation of liberty is so great, and maybe, if you come from a different context, you don't see it, but that's the way it is. It's so great that the judge has to actually see the person and find out what's the problem. Because there have been too many instances where things have gone through on paper which have turned out to be really problematic, and the legislature said, no, there shall be a hearing. Maybe CPCS is there, maybe CPCS isn't there. I take it in most cases CPCS is the one making the claim. Here, that was not the case, correct?
That's correct. But never once in the more than 100-year history of Massachusetts having a mental health statute has it ever been determined that the full evidentiary commitment hearing that's required has been deficient in any way. So this is one additional procedural protection that affords near immediate judicial oversight on a patient's admission. And so when you take that in the context of what else had been changed when this was added to the statute in 2000, prior to 2000, an emergency psychiatric hospitalization could last for up to 10 days. And prior to 2000, the district court had up to 14 days in order to schedule a hearing on the 7 and 8.
I have to say, Mr. Porter, that on its face, to say that somebody was claiming that he was unlawfully detained in defiance of a court order to discharge him sounds about as close to abuse, or misuse. Court orders discharge, and I am not discharged. Somebody enters another order to keep me. I don't know else what constitutes abuse or misuse, but it seems to me that's pretty close. Just to say, well, let me have a look, let me hear what your problem is. If that's the low threshold.
But I thought that in this case, when I asked the Mr. Magrini's attorney the question, he said that the only complaint they had was the procedural defect that he had been ordered discharged and wasn't discharged.
Well,
But that's not one of the provisions of the subsection 12B.
Of course it is. How can it not be?
It's not, because the language is clear. When it lists the provisions of subsection 12B, you can't be admitted immediately upon arrival to a hospital unless you've been evaluated by a physician with admitting privileges. If when you come to the hospital you haven't been so evaluated, then you're required to immediately psychiatrically evaluate that person. And only if that doctor with admitting privileges makes a determination that failure to hospitalize that person at that time would create a likelihood of serious harm is an admission appropriate. And the other provision that is incumbent upon the hospital at that time is that once the patient has been admitted, that CPCS be immediately notified.
Yeah, but the language is reason to believe that the admission, this emergency admission under 12B, reason to believe that this admission is the result of abuse.
But again,
how can advising him that a lawyer can be made available be what this was intended to get at?
It gets back to the error or mistake that I had highlighted in the appellate division's use of the 12A arrival to the hospital as tying that to be the date that Mr. Magrini had been initially admitted.
He seems to be saying, though, in the motion that the abuse is the fact that I am now being hospitalized after the hospital told me, or after the court told the hospital to let him go. It's a reaction.
I'm now being hospitalized under this emergency provision after I was told the court ordered me released. It may be that's not, as it turns out, an abuse and that it was justified under the circumstances, but how can that not be covered?
Yeah, it's classic
By this-
abuse. It's
Wouldn't
a
it-
backlash.
Wouldn't it fall within that prong of 12B that says if he's been ordered discharged, there's no likelihood of serious harm?
But again, this
Which
was
you
a
agree can be examined under 12B, correct?
This was a determination made by the court without any substantive review of the appropriateness of the hospitalization itself. It had nothing to do with diagnosis. It had nothing to do with level of dangerousness. It had everything to do with a procedural defect in the patient's admission status in the
Why isn't
hospital.
that an abuse?
Yeah. It goes to the motivation for the admission in the first place, or for the June 19th admission.
And again, according to the Carjavani case and the line of cases that follow it, the motivation has nothing to do with the appropriateness of admission. So in other words, when the appellate division is highlighting good faith on the part of the hospital, respectfully, although I concur, it has nothing to do with the appropriateness of the admission itself. When Mr. Magrini raises the issue of
don't
that this
think
is
that
some sort of malintended effort because the doctor was mad at the judge, that too has nothing to do with the appropriateness of the
Wait a
admission.
minute,
can't be
Are
right.
you saying that if, forget this case, but let's say that the allegation is that the doctor has admitted me because my mother has this grudge against me, doesn't want me home, and has bribed the doctor to admit, none of that would come in?
What I am suggesting to the court is that if the district court judge deems that information that comes to the court sufficient to have a hearing that further fleshes out these issues, then of course the hospital would agree that a hearing is required when the judge orders it. However, I would also stand here and ask the court to consider, based on all of Chapter 123 and based on the legislative intent behind the changes that it enacted in 2000, that the court retains the discretion to make a determination on whether further hearing is required. And again, the rationale that this court used in Thompson versus Commonwealth in 1982 still applies today, that if you are allowed to have a process where a hospital is going to be required at any time to come and
Hospital
justify
doesn't
its
have
own
to go.
justify its own, but the court used
Hospital
that
doesn't-
rationale to limit what a
Hospital-
commitment appeal would allow for.
Mr. Porter, the hospital doesn't have to go. If the hospital is absolutely confident, the hospital can have the counsel for the patient go. The
Anyway,
hospital doesn't have to go.
we'll sort it out.
Thank you, Mr. Porter.
Thank you.